Many people believe that whenever they're on anyone else's property, whether it be private property, a residential property, or for that matter, in a grocery store, in a mall, and they fall and they're injured, that they automatically have a claim. That's not true. You have to be able to prove that there was negligence by either an affirmative act or by a failure to act, by an omission, and maintaining the property in order to prevail on a lawsuit for your injuries. You simply can't say, just because I was at the supermarket and I slipped and fell on water on the floor, therefore I'm entitled to be compensated for my medical bills and my pain and suffering and for my lost wages. That's not accurate. You have to be able to prove that the owner of that grocery store, the party that was in possession of the store, did something that was negligent. So for instance, if they knew there was something that had fallen onto the floor, such as somebody spilled water, and they knew about that, and they didn't do anything to correct the condition, and it was allowed to remain there for a period of time, and somebody came along and slipped and fell, then there would be liability. But by way of an example, if you're walking behind somebody in a grocery store and say a child in a shopping cart spills some juice onto the floor from his sippy cup, and you come upon this juice within a minute after that's spilled, there was never a time for the shop owner or the grocery store owner to have cleaned that up. So as a consequence, there would not be negligence. And even though you fell on those premises, it was not the grocery store owner's fault, and there would be no negligence, and there would not be a claim.